Hello. Welcome to podcast number 3 on the basics of patenting. This is Catherine Toppin. I'm a member of the IEEE, and I serve as patent counsel at the global patent operation of the General Electric Company.
Hello. This is Brian Gaff. I'm a senior member of the IEEE and a partner at the Edwards, Angel, Palmer & Dodge law firm in Boston. The IEEE is presenting this podcast in conjunction with a series of articles that I co-authored on patent law. These articles appear in Computer Magazine beginning with the July 2011 edition. The goal of this podcast is to supplement an article Catherine and I co-authored, which was published in the September 2011 issue of Computer Magazine entitled 10 Things to Know When Your Patent Application is Allowed. Now that you have been through the difficult process of obtaining a patent from the USPTO, your invention is one of an elite group of about 8 million U.S. patents, giving patentees the right to prevent others from making, using, selling, offering to sell, or importing the patented invention without the inventor's permission during the life of the patent within the U.S. The question now becomes, how do you, as the patentee, exercise the rights that the government has granted you? Licensing and patent litigation are two primary ways that patentees exercise the patent rights that they have obtained. We will discuss some of the basics of each of these options in turn. Catherine, why don't you start us off?
Thanks, Brian. Patent licensing is the selling of all or a portion of your patent rights to a person or business that wishes to produce it for a profit. Licensing may be an attractive option for you to monetize your patent, particularly when you are not able to commercialize the product yourself for financial or other reasons. A license is essentially a contract that gives the licensee legal permission to make, use, or sell the invention under certain terms and conditions. Some questions to consider before entering into a license agreement are, can you prove ownership of the patent? Can you demonstrate that your idea has commercial viability? Can you sell your idea effectively? And have you researched prospective licensees? Be sure to learn about the industry and the companies to which you are considering licensing your invention. One of the worst mistakes you can make as an inventor is to solicit a company blindly without knowledge of that company or the overall industry. Unlike patent prosecution, preparation and enforcement of license agreements are based on two bodies of law: the law of contracts, which enforces the promises of people, and the law of torts, which enforces the reasonable conduct of people, both of which typically vary by state, unlike the federal laws that govern standards of patentability. If your answers to these questions have led you to the conclusion that licensing is the appropriate route for you, you should strongly consider hiring an experienced lawyer. Don't go it alone. Your attorney will aid you in negotiating various provisions of license agreements, which typically include provisions for upfront payments, royalty percentages, and infringement issues. For example, you will need to determine whether you want to give an exclusive license to one party or a non-exclusive license to more than one party. You can also decide whether or not to set a time or territory limit on the license.
Irrespective of whether you have decided to license your invention, you may choose to exercise your right as a patent holder by initiating a patent infringement action against a suspected infringer. A defendant can be held liable for patent infringement if he or she engages in one or more prohibited acts with respect to a patented invention without permission from the patent holder. Remember, infringement of a patent is determined with respect to the claims of the patented invention, and infringement of all elements of just one claim can result in a finding of infringement. Courts are not required to consider the intent of a defendant when making their initial determination of infringement. In other words, even if the infringer unintentionally practiced the patented invention and was completely unaware of the existence of the patent, he or she can still be held liable. Before initiating a lawsuit, patentees have their legal representative send a demand letter to someone that they believe may be infringing. The demand letter puts the accused infringer on notice of the patents as an infringer who actually knows of the patent that he or she is infringing may be subject to enhanced damages for willful infringement. An improperly worded letter sometimes called a cease and desist letter, can create an opportunity for the accused infringer to sue you. So ensure your letter is written very carefully. Because patent infringement cases are governed by federal law, that is, by United States Code, they are heard in front of federal court. In many respects, the fact that patent infringement is a federal issue makes the law much more consistent because there is not a state-by-state variation in the patent law, as would be common with most business and contract issues.
A patent litigation suit is officially commenced by the plaintiff, or patentee, who files a complaint against the defendant or accused infringement in federal court. Where a case will eventually be tried is often a critical determination that can affect the very outcome of a case, because certain laws in particular jurisdictions may be more favorable from a procedural perspective, so be sure to choose wisely. Defendants have a limited amount of time to respond to a complaint once it has been received. In the event he or she fails to respond, the court may enter a default judgment against the defendant that, unless later reversed, acts as a finding of guilt on the issue of infringement. The court may then impose a monetary judgment against the defendant. In the normal course of litigation, the defendant makes a response called an answer, which serves as a defendant's first opportunity to defend the case on the merits. In addition to responding to the accusations of the plaintiff, the defendant also has an opportunity to bring counterclaims against the plaintiff.
Discovery is the next stage of a patent infringement case. Like other civil cases, discovery is a fact-finding period that allows both sides to conduct depositions as well as to inspect records and documents that are in the hands of the other party. With the advent of email and electronic databases, discovery has become a costly and time-consuming process based on the complexity, volume, and type of discovery involved. After discovery, the court usually conducts a hearing called a Markman hearing. A Markman hearing is a hearing where the court decides what the claims mean. Trial of a patent case generally follows sometime after the Markman hearing. Despite the expense and time investment of discovery, however, a large majority of civil cases in the federal court do not go to trial. Many are dismissed by the court, or if the facts are overwhelming on one side or the other, the court may enter summary judgment, giving victory to one side. Many cases are settled by agreement of the parties just prior to the trial or even earlier. Because patent infringement cases are notoriously grueling and expensive, many defendants make a strategic decision to settle cases to avoid the potential costs associated with trial. While some preliminary matters are decided by a judge, most patent cases have their primary issues decided by a jury. Both parties are responsible for giving the judge a tutorial on the technical issues at issue, so he or she is able to understand the technical merits of the case. Patent trials last anywhere from a few days to a few weeks, depending on the complexity of the technology, and they include direct examination of witnesses, experts, cross-examination of witnesses, and a number of documents that are placed before the jury. Attorneys for both sides will make arguments intended to cast the evidence in the best possible light for their side. In the end, the case will go to the jury for a decision.
Defendants have a number of options to argue when being accused of infringement. The simplest defense is non-infringement. That is, the accused device or method does not infringe the claims of the patent. In addition, the defendant may argue that a plaintiff has not followed the correct procedural steps. Even more commonly, defendants often allege that the patent itself is defective in some way. In other words, the defendant asserts that the patent is invalid. Often, defendants will engage in the re-examination procedure available at the USPTO to assert additional prior art documents against the patent. The court has the discretion of whether to grant a stay or a delay of the pending proceedings in order to await the determination of the USPTO. If any of these defenses prevail, the patent may be held to be invalid, thereby resulting in a victory for the defendant.
Whether you decide to license, litigate, or both, be sure to avoid simple pitfalls by keeping accurate records regarding the chain of title to your patent and by paying all maintenance fees in a timely fashion. We hope you found this series of podcasts and associated articles helpful as you navigate the patent application process. Until next time, this is Brian Gaff of Edwards, Angel, Palmer & Dodge.
And Catherine Toppin of General Electric Corporation.
Feel free to contact us via email at bgaff@eapdlaw.com
or at catherine.toppin@ge.com. Thank you.